Hey guys, I'm Combat Craig, and if you're a veteran that's interested in hearing loss claims and hearing loss compensation, then this video is for you. Today's topic is hearing loss claims. We're going to be going over a decision letter. I took the decision letter and I put it in text format, and then I wrote notes under the parts that I think are important to me and important for you to know. I put timestamps in the description so you could skip around the video. Uh, this is the way I look at it. I'm not accredited, and I look at things the way I look at things. We're all in the education process here, so it doesn't matter if you're a beginner, intermediate, whatever. Understand what you understand. Understand it. Uh, is good enough so you know how to win your claim. There's many arguments. You can argue all decision letters multiple ways. A VA lawyer will argue, one set of tactics based on the merits of the law. A doctor will probably argue with his own opinion, his own independent medical opinion, or by filling out a DBQ for you. That's how he does his argument. In both cases, you're going to, have some kind of paperwork. There's HIPAA laws for the doctor. VA lawyers need to get a power of attorney and stuff. And typically they don't come on and deep dive into these things and explain things. I'm not any of those guys. I can explain whatever I want. I fought for this country, free speech. So that's what we got going on here. I want you guys to just win. That's why I go through and do this stuff. That's why the Combat Craig channel exists. So let's hop into the video. Service connection for bilateral hearing loss. Up front, I'm going to be going through all the actual numbers, hertz and decibels, and you go to an audiologist for your C&P exam and beep, beep, beep. I'm not going to translate all that stuff for you. I'm going to just kind of summarize it. So just that's coming. Want to give you a heads up. So service connection for bilateral hearing loss is denied. Have you ever heard that? Like, have you filed a claim for hearing loss? Are you appealing a claim for hearing loss right now? Any of those kinds of things. Leave a comment below. Let me know where you're at with your hearing loss claim and if this is resonating with you. And let me know if you like these kind of videos as well. You can hit that like button. So service connection for the right ear is denied because your hearing loss has not been linked to service. Service connection for the left ear, I kind of rammed those words together, sorry, is denied because there's no evidence that you currently have a hearing loss for VA purposes. 38 CFR 3.303, 3.304, 3.385, those are the laws. These are the laws that they are basing this denial on. I encourage you to literally grab it and copy it and put it in the Google box. The law will come up. Read it. Read it and understand it to the best of your ability. But at least read it enough to understand how to win your VA claim. You have to do a lot of this education on your own, period. So basically what this is saying here, your right ear is not service connected because you don't have a nexus linking your right ear to service. It says right here, linked to service. Anytime you see the word link or a variation of the word link, like linked with an ED after it, that means nexus. So that's something that you need to keep in mind. Your left ear is not service connected because you don't have a current diagnosis. The way they say it is there's no evidence to say you have hearing loss for VA purposes. For the purposes of, I can't hear shit. I've gone to an audiologist and, I'm deaf and all that kind of stuff. That's not even what they're arguing. They're just saying you never proved it to us, so we don't see a problem here, essentially. Here's all the different decibels and hertz and stuff like that. Again, I'm not going to sit here. If you want to take a screenshot of this, I'll move my mouse out of the way. But yours is going to be different. That's why I'm not going to deep dive. Everybody has different hearing things. I've done this audiologist. I guarantee you mine is completely different than this guy's. Probably because mine's better. I never even filed a claim because I don't have hearing loss issues. Couple things. I would never file a hearing loss claim anyway, personally. I like high value claims. But I have been in one of these booths before. So it's different for everybody. But, to summarize it, there's a VA rating chart for hearing loss claims. And when service connection is confirmed, the VA will assign a disability rating based on the severity of the condition, right? Diagnosis, severity of your symptoms, severity of condition, same thing. Nexus, got to have that. And then they plug it into this chart here. So take a look at this chart. It isn't, I wouldn't recommend deep diving into this chart. You have 500 decibels minus 23 other negative decibels, and you're right here. So you get 50%. So understand how they rate it, but this isn't a subjective claim at all. You're going to go in there and hear what you hear, and then they're going to, come over and they'll probably put you over here. They love using this scale. It's usually 0, 0, 0. And then if they go down this scale, it's like, 0. Oh, there's a 10%. Better start going this way. This is why you get screwed and why it's 0% all the time. There are no audiometric findings in your service treatment records that meet the above requirements. Although hearing loss is not shown in service, acoustic trauma or military noise exposure may constitute injury of the ear. There's another word to pay attention to. It may constitute. This does not say it does constitute. We know it happened in service. We think you should get a VA disability rating. The word is may, not what you want it to be. Don't read into these things and insert words that aren't there. May basically means nothing. Like cows may fly someday. I personally don't believe that, but weird shit's happening out there. Anything may happen. Medical expertise is needed to establish a link between your current hearing loss and in-service military noise exposure. However, to this date, we have received no medical records showing that your right ear hearing loss is due to service. Every time they say link or a variation, it means you need a nexus. You have in-service acoustic trauma. Wow. They said may. They said I had in-service acoustic trauma. Hold your horses there, Roy Rogers. This isn't necessarily good. They do this. This is the way they speak to you. Here's some good things, but you're denied. We may be able to do this, and cows might fly. Denied. That's just the way these decision letters are. They're built to screw around with us. And, by the way, until you actually stop that and put up a fight, like at least an appeal and at least not quitting, until you do that, educate yourself about the process and get serious, they're going to keep fucking with you with stupid verbiage and blowing you off and stuff like that. Once you get serious, they realize you're not a pushover anymore. And you're going to sit there and fight them till the day you die. And that's the mindset you need to be in. And then you need to protect your rating. So we have, you have in-service trauma, but service connection for your left ear based on military noise exposure alone cannot be granted. It could, they're just not going to do it. For service connection of the left ear to be considered, there must first be a showing of actual hearing loss. What the fuck does that mean? Actual hearing loss? I have it. I can't hear shit. Well, they don't know that because you didn't prove it. And also, you're for sure going to get angry when you get your decision letter. All of them, whatever claim you file. Your first reaction should be, I waited 6 months for this bullshit. So that's going to happen. You're going to be angry and you're going to do whatever you do when you're angry. Just put the letter away if you don't burn it. You need that letter. But you need to come back to it, and you really need to understand these words. And the best way I could describe to read your own decision letter is you need to remove yourself out of the claim, because when you're taking it personal, you just get pissed and you can't understand, like you're just angry. Again, this is a special tactic the VA uses. They do this to play with you. Again, once you just decide, I am not going to let the VA play games with me anymore, and you decide to win, it just changes. For me, it happened about 2 years ago. This YouTube was created because I want my own way of fighting back. I'm not going to get the 27 years of being underrated and stuff. And it was my fault because I didn't educate myself. But I can help you guys get rated faster. And that's the goal here. Moving on. Your VA examiner opined that it is less likely than not. That's a death sentence for your claim. Just in case you didn't have enough, you don't have a diagnosis in one ear, you don't have a nexus in the other ear. Now you have less likely than not, and I'm going to explain that here in just a second, so bear with me. That your hearing loss is due to military noise exposure. The examiner provided the following rationale: lack of evidence of hearing loss during active duty service and lack of evidence of a permanent, positive, and significant hearing threshold shift during such service. So there's a couple other words here. Your VA examiner, like your boy, that's kind of what they're trying to do to you. And then your examiner, he's not your he's the enemy. He is not your boy. He's not your examiner. They're just trying to convince you that he's some kind of independent entity. He is hired by the VA to fucking deny your claim. Not all CNP examiners are like that. And if you're a CNP examiner watching this, if you're doing this to veterans, you're a complete piece of shit, and you should quit your job and go work somewhere else because you hate veterans. You can hate veterans. That's why we fought for this country. We can have free thoughts, free speech. But if you hate veterans, quit working for LHI, VES, and QTC and go work somewhere else. And maybe you should take up kids. But then you'll probably be a dick there and whatever. End rant. So, not your CNP examiner, right? Another point that I would like to make is hearing loss claims are not tinnitus claims. Hearing loss has one diagnostic code. Tinnitus has another diagnostic code. They're often filed together, and they're almost always examined together at the enemy's CNP exam doctor at his office, at the audiologist. But they are not the same claims. They're two separate claims. So a lot of times they'll crosstalk in decision letters. You have your tinnitus over here and your hearing loss. Separate them out. It's literally like the difference between your foot and your elbow. Completely different body parts, rated differently, that kind of stuff. Want you to be aware of that. There's 5 legal phrases. And your private doctor should be using these phrases because the CNP examiner will be using these phrases. They're goofy phrases, in my opinion, but they're legal VA jargon. Like, this is the legalese. It's not a good idea to speak VA legalese. This is the argument. I wrote it exactly like this because guess who is going to be using VA legalese? Your CNP examiner when he's bending you over. So there's 5 of them. Is due to, that one's pretty straightforward. 100% certainty that this disability was caused or made worse or aggravated by service, your active duty service on a direct service connection basis, secondary service connection basis, pre-existing service connection, presumptive service connection, whatever the case may be. The next one down is more likely than not. This means a greater than a 50% chance. At least as likely than not. This was equal to or greater than a 50% chance. I underlined this one, and I'll explain. Less likely than not means less than a 50% chance. Is not due to is a 0% chance. So the main thing that you need to take away from all this verbiage is if you have any doctor, whether you hire them or a CMP examiner, if they give you these two, your claim's dead. It ain't happening. Nexus is not established. These three are good. So go for good. Don't go for bad. Now, this one is really weird for normal people that haven't seen this language. At least as likely than not. Like, whatever. I'm not like super college educated, but I wasn't even speaking like that in kindergarten. It's just a weird standard, but essentially it means equal or greater than a 50% chance. There's a tie goes to the veteran rule. You are proving your claim. That's what we do when we file a disability claim. You may not do a very good job at it. I know I did a piss poor job multiple times, but when all the evidence is in and all the decisions have been made, if you come up to a 50-50 and it's a tie, the tie is supposed to go to the veteran. That's why equal is plenty, greater than is fine too. Usually you're not going to get is due to because you don't need your doctor to go out that far on a limb. He doesn't need to be like, I am 100% sure the migraines are caused by the tinnitus. He just needs to say, there's a 50-50 chance. And then on the other side of this, CMP examiners, if they're being dicks, they'll write is not due to, but they don't need to go that far, and they usually don't. They usually use this one, less likely than not. So to get a favorable decision, you're going to need to get a copy of your VA claims file because you need to see what the CMP examiner wrote. And you need to use the medical records that you submitted along with your claim. And you need to bring all that and this denial letter, and you need to bring all this stuff to your private doctor and explain what happened. You know, they didn't see this because I don't have a nexus. I went to the VA. They don't do nexuses because they're dicks. Can you hook me up with a nexus doc? Absolutely. Oh, by the way, thank you for your service. That will be the time. Thank you for your service is actually relevant because he's a private doctor and he appreciates that he was able to go to medical school and make whatever, $350 a year. So those guys tend to actually like veterans, unlike CNP exam doctors and VA doctors. I don't have no clue why they just don't like us. They should clear them all out. So that's how you get a favorable decision. You challenge the CNP exam with medical evidence from a private doctor, and your private doctor basically looks at the circumstances, pre-filing claim, but really all you're doing here is just trying to appeal this claim. And then he's just going to go through and say, nope, guy's a moron, didn't use the right tools. That's not an audiologist test. He was using a goniometer or whatever, or this dumb shit. He did a range of motion test when he's supposed to be doing hearing tests. So however he's going to argue it, like I said, there's a lot of ways to argue these things. Now there's one more thing that you should consider. I'm not saying don't go after hearing loss claims. If you currently are not service connected for hearing loss, being service connected for hearing loss at 0% is better than not service connected because you can file secondaries, although it gets a little tricky, but you could do it. Hearing loss, here's how it works. Here's the bottom line. So you win your claim. You go pay money for a private doctor, all this stuff. The VA is going to come back, stick hearing aids in your ears, and then say, there you go, you don't have a problem. And you're going to be like, what do you mean? I'm 23. Yeah, we don't care about your age. This is where that age kind of works against you when you're younger. But when you're older and you're trying to do TDIU claims and things, and you're in your 80s or 90s, they can't use your age against you then either. In most cases, they can't use your age against you. But they're going to just be like, hey, man, you got hearing aids and you hear fine, right? Like, yeah, but I got hearing aids. That's That's not the way they look at it. You hear fine. That means you no longer have a disability. Well, sometimes the batteries die. Well, then charge them. Like it's just that's the way they look at it. I don't agree with it. Obviously, I don't agree with a lot of goofy stuff the VA does. Anyway, check out my boot camp at combatcraig.com if you want to learn more about the VA claims process and the process I use to get to 100% permanent and total. And if you're interested in appealing a claim and you need a VA accredited lawyer, you might want to go take a look at Hill and Ponton. I left a link in the description, and their website's hillandponton.com. I will see you in the next video.